we published our very first guide on the UN Guiding Principles specifically for the legal profession. The aim of our report was to assist the legal community and their businesses to begin to address some of the key issues in respect to implementing the UN Guiding Principles on business and human rights. So over the course of the next 2 hours, we are going to hear about the relevance of the UN Guiding Principles to being a responsible business. Now, we also want to hear from you all, so there will be an opportunity to discuss your thoughts as we want to make this session as interactive as possible. For now, your microphones will be switched off. We're also going to record this part of the session, so you might be able to see it again. Now, I'm delighted to say that we have an exceptional group of contributors who all come to business and human rights from very different backgrounds and different parts of the world. Our first speaker is Hanningtone Amol, who is the Chief Executive of the East Africa Law Society, and he will be making the opening remarks on behalf of EALS. So Hanningtone, can I invite you to speak?
Thank you, Yasmin. Good afternoon, ladies and gentlemen. On behalf of the East Africa Law Society, receive greetings from the President, Willie Rubea, and the Governing Council. We are pleased to partner with the Law Society of Kenya and the Advocates for International Development, Enroll UK, to bring to you the very first webinar on responsible business. I know Yasmin has already talked about business and human rights. So when you hear me talk about responsible business, that's exactly what you mean. We know in the room, many of you already understand what BHR principles are, but then there could be a few who are still, hanging in there. So all through this afternoon, we'll be discussing responsible business in a corporate setup. Our partnership with A4ID, that's Advocate for International Development, has run at least for the last 3 to 4 years. In instances you've met us personally, come to train you in person. We hope to continue this when the current measures are taken away, when the COVID pandemic effects is. Now, in these welcoming remarks, I would want you to deeply reflect, 1, why talk about responsible business, and 2, why we are giving priority to in-house counsel. And probably you might want to ask yourself, why Kenya? You notice we are focusing this one on Kenya. Why Kenya, not any other place? Now, the changing world requires that corporations reflect daily on how responsible their business practices are. Are they observing existing human rights standards? Are they observing community rules? And generally, are they living as good corporate citizens? And this is not just a matter of the usual corporate, what you call CSR, corporate social responsibility. No, this is deeper, with obligations that have already been recognized by UN. And as we all know, and we've seen in the recent protests in the US, that an irresponsible corporation could actually lose business in terms of losing its reputation, losing customers, and losing so many. You saw what happened to the CrossFit gymnastic group just within this week. And for in-house counsel, you learn that and you appreciate that you are the bastions of compliance within your settings. That when a corporation fails, especially for being non-compliant, the first person who will be held responsible alongside the chief executive officer is the corporation secretary, and by and large, the legal department. And that is why we think, even though you will need assistance of the external counsel, you must first understand the business and the responsibilities that you will be asking the external counsel to assist you with in terms of responsible business. And for Kenya, because Kenya has made some good steps, Kenya has shown some progress, but there's still a lot that needs to be done to appreciate and incorporate BHR into our daily practices. I want to appreciate our speakers this afternoon, Catherine, Howard Morris, and the team from Clifford Chance, and any other person joining us to speak. I can't mention each one of you by name, but you are going to meet them. These people have dedicated their time, dedicated their skills to help us appreciate these emerging issues, and I really thank them. I would also want to thank the Law Society of Kenya for being proactive, for giving us the very first platform, and for giving us access to their in-house council membership to ensure that this training runs smoothly. We'll be speaking more and we'll be interacting more through the day. I invite you to sit back, listen, and interact with the speakers of the day. Thank you. Back to you, Yasmin. Yasmin, are you still there?
Yes, I am. Thank you very much. I just had to unmute myself. Thank you very much, Hanningtone. Now, our next speaker is Ndinda Kinyili, who is the convener of In-House Counsel Committee of the Law Society of Kenya. And she'll be making the opening remarks on behalf of LSK. So, Ndinda, can I invite you to speak, please? Ndinda? Can you hear? Hello, Ndinda.
Ndinda, I believe you are on mute.
Ndinda, is she there?
She is there.
Ah, Ndinda. Can I invite you to speak, Ndinda? We can all see you now as well.
Yes, but please do. Can see me now?
I think we're having a little bit of what you call technical problems, which means that, well done, Ndinda. Have you moved somewhere else that's more easy for us to be able to, okay, in that case, can I invite you to speak?
Good afternoon, everybody. My name is Ndinda Kinyili. I'm a council member for the Law Society of Kenya, and I'm the convener for the In-House Counsel Committee. It's a pleasure to be with you this afternoon. There is an increasing demand on the role of the in-house counsel. It has become mandatory to embrace changes, to navigate the fast changing legal and regulatory frameworks, as well as the systematic shifts in the legal industry itself. It's a pleasure for the Law Society of Kenya to Africa Law Society for this webinar. We hope that this webinar will provide an avenue to share experiences on these risks in terms of crisis. Looking forward to the fruitful deliberations.
Okay, I think that is, thank you, Ndinda. Great. So now on to our main speakers. I'm delighted to welcome Howard Morris, who is the legal counsel at Morrison Foerster, and his colleague Chiraag Shah, who's a partner also at Morrison Foerster. Morrison Foerster are one of A4ID's legal or law firm partners. Now, they're going to do a double act, introducing the UN guiding principles of business and human rights within the context business. They're going to also address corporate responsibility. And they will do so by looking at the role of the in-house counsel in ensuring responsible corporate responses. And they're going to do that in respect to mitigation of legal risk, and also reputational risk. And they're going to tell you all about this in 20 minutes. So on that basis, no pressure there. Can I welcome you both to start and speak?
Thank you, Yasmin. Thank you, everybody. Good afternoon. I'm Howard Morris, and the way that Chiraag and I are going to tackle this is that I will take the first element of our presentation, an introduction to the United Nations Guiding Principles on Business and Human Rights, and then Chiraag will look at the next topic in relation to the role of in-house counsel. And if we can move to the next slide, I only have a couple of slides. So what are the UNGP? Because you, like me, may well have heard of them for some time before you actually got to grips with them. And I'm going to say that for lawyers, they're quite hard to get to grips with because, and that's one of the key elements about them, because they're not entirely law in the sense with which we're familiar. So the UN Guiding Principles on Business and Human Rights are actually 31 principles that support what are referred to as the three great pillars. The three pillars, the duty to protect, respect, and to remedy human rights violations. Protect. Well, the protect pillar is one that the United Nations has been pursuing since its establishment at the end of World War II, to protect human rights. The whole concept of human rights as an area of law sprang out of that terrible conflict and the genocide, and understanding that there really should be a corpus of law and practice devoted to protecting human rights and identifying how those human rights could be articulated. And the way the UN worked is in a very orthodox way. It sought to impose responsibility on independent states to be responsible for human rights in their jurisdictions and in their behaviour. Where the UN principles, the guiding principles, have actually marked a significant departure, and it ties in with the Global Compact, which is another big UN program, is to recognise that the world, I won't say is run by businesses, but is heavily dependent upon businesses, and that businesses shouldn't escape responsibility for protecting, respecting, and remedying human rights. And so what the UN Guiding Principles do is to take responsibility for those three pillars and place them on the shoulders of businesses, not large businesses or small businesses, but all businesses. So we're talking about the multinational natural resources business, the international oil companies, airlines, huge financial institutions, but we're also talking about Joe with his bike and his bucket who cleans windows. We're also talking about the guy who supplies fruit. We're talking about the grocers, and we're talking about the tobacconists. We're talking about the motor taxi. We're talking about every business of every size has a responsibility scaled to what it's capable of achieving to support these three pillars. And these three pillars are directly relevant to the principles 1 and 2 of the United Nations Global Compact, which is something to which over 9,500 businesses internationally have signed up to. They have committed themselves to this. And those first two principles are their obligation to respect and support the protection of internationally proclaimed human rights, and number 2, not to be complicit in human rights abuses. Now, the whole point about this, as I said, is this is not law as we know it. This is often soft law. And as Hanningtone so rightly said, you as in-house counsel, me as an external lawyer advising my clients, have to be mindful of risks. We advise on risk. And of course, the risk of an adverse judgment by a court awarding compensation to a plaintiff is something about which we are most especially concerned. But we need to be aware more and more of the risks of being judged in the court of public opinion. And Hanningtone referred to the Chief Executive of CrossFit, who's had to resign this week in consequence of ill thought out, ill judged and deeply offensive social media posts in relation to the Black Lives Matter campaign following the murder of George Floyd in the United States. The behaviour of individuals within enterprises, the behaviour of enterprises now can't be easily hidden. It goes round the world. And of course, social media isn't always a fair judge. It isn't always, or you might say infrequently is, a proper judicial body in any respect, in the sense of listening to what people's response and defence might be. People rush to judgment. But it's the risk of damage to one's business that follows from public outing for behaviour that can cause far greater damage to a business than any award of a court of damages. And so as lawyers, we need to be alive to this, because the responsibility is placed there. The question is asked of companies to be responsible. When I say companies, I mean enterprises. So whether they are a company, a sole trader, a partnership, whatever, they are responsible for those three pillars. If we can turn to the next slide, please, soft law in action. I can't possibly, in the time available, go through all the 31 principles. Dare I say, for something which has a legal aspect to it, that a lot of it is common sense. You won't be surprised by its contents. But there are two aspects I particularly want to focus on, and that's mitigation and leverage. The responsibility to respect human rights requires that business enterprises seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products or services by their business relationships, even if they have not contributed to those impacts. In other words, if I'm Apple selling iPhones, I have to be aware of and I have to take responsibility for trying to stop, to influence human rights abuses that might be going on in the factories around the world where components for my iPhones are made. And we know that in China, there were serious concerns about the mental health of employees at a factory that made Apple products. So what this piece of this principle, this is guiding principle 13B, what that does is that you've got a responsibility as a business, not just to address what your staff do, not just to address what your businesses do if they're extractive in the natural resources field, what they do, but also what happens in your supply chain. And it's not enough to say, I don't know what other companies, businesses who supply me are up to. That's not good enough. One has to be curious, one has to investigate, one has to carry out something you'll hear a lot of in relation to the guiding principles, human rights due diligence. There's this know and show element. Your business will have to have a human rights policy, and I'm pretty sure responsibility for drafting that and agreeing it with the executive functions in your business will fall on your shoulders. Who else are they going to go to except the in-house counsel? You've got to conduct appropriate due diligence, and that's in two aspects. You need to due diligence the human rights aspects of what your own business is doing now and really historically. Because if there's one thing we see now is that sins that were committed in the past are being are being brought out into the open and examined and subject to scrutiny. But also when entering into any sort of relationship with a counterparty, a joint venture or an acquisition, or indeed a sale, you've got to carry out a human rights due diligence then to be satisfied that you're not going to be taking over acquiring a business where human rights are not protected and there is no remedy for abuse of human rights, or that there are unsolved, unremedied human rights abuses, or that they might continue the way that business is done, the way that the business is operated. But also you've got a responsibility that if you transfer a business to an acquirer, they aren't going to then behave in a way which is inimical to human rights principles. You've got to develop processes to remedy impacts. And the important thing about the remedies is that they are judicial, traditional, being sued in courts, but also non-judicial remedies, mediations, arbitrations, even just having a system for sitting down with the people affected and giving them an audience, a platform to articulate their issues in front of people with the power to remedy them within the company. So you've got to be alive to all those elements to show that you respect human rights, and you've got to use leverage. And here's an important point. Leverage is one of the words that we use commonly in business, and we hear it being spoken about by all the business people we serve about their leverage in negotiations, their leverage to achieve a result that they desire. The UN guiding principles want our businesses to use their leverage in order to improve the protection and the remedying, and of course respect for human rights. In other words, if someone wants to, if I'm sending out a tender for someone to supply me with raw materials, as much as I will want to be able to make sure that they can supply the standards, they can supply on time and in the quantities I want, and they will remedy problems in relation to the supply, I also want to use my leverage that people receiving the tenders want my business to ensure that they achieve the highest human rights standards. So that's using leverage. That's using the power that you have as an enterprise to ensure that everyone you deal with also meets those standards. And you'll see that now in the Equator Principles. If you're involved in a joint venture, you want financing for it, for some sort of project, you're going to struggle to get financing unless the business and the proposition and the individual companies, enterprises involved, meet high standards of human rights protection. So there is no escaping the reach of the UNGPs. They've been around for now nearly 10 years. They are becoming even more popular. And while they don't consist of black letter law in the sense of failing to protect human rights will always result in the ability for someone to bring a tortious claim against one's business, they nonetheless carry very powerful remedies and sanctions for default. So that's a brief introduction to the UNGP. They're very easy to study. There's an awful lot of material written about them. And the job that we're going to look at today is how we fold them in to businesses which already have increasingly wide responsibilities in terms of regulatory compliance. And now Chiraag is going to focus on the responsibility and role of in-house counsel.
Thank you very much, Howard. I hope everybody can hear me okay. So turning then to what we, and I'll use the term in an inclusive way, as in-house counsel can do to help drive this forward, but also what we need to be thinking about and be cognizant of within our individual businesses and enterprises. And so let's start from the outset. What is the traditional role that in-house counsel have focused on? And that has been, what is the legal risk? You very often will be asked in relation to a transaction by the business or the management team, what's the downside? What could happen if we go down this route? What is the commercial risk? So, but all of those areas will typically focus around contractual rights, around legal rights, statutory provisions, and that's where the UNGP departs from the norm. And what it does, and harking back to what Howard just said, is the UNGP doesn't create new law. It's largely a soft law element. The three core principles of respect, protect, and remedy is what needs to be implemented. And as Howard's already mentioned, there's significant downsides. It's particularly important here to recognize that simply engaging in corporate social responsibility exercises isn't going to be sufficient. There needs to be positive steps towards fulfilling the three core themes towards the protection of human rights in a business context. So what are the risks and consequences if we fall short on any of these? The legal responsibility as the first step. There are numerous cases, particularly in Europe and the US, where parent companies, for example, have been held or at least sued on the basis of acts by subsidiaries, by contracting parties. Howard gave the example of Apple and the censure it faced in relation to conditions in factories in China. Primark in the UK has faced challenges around sweatshops in India and Bangladesh. So the legal responsibility, and that is your typical claim for damages brought before a court, or more recently following the implementation of the Hague Rules on Business and Human Rights in arbitration rules in 2019, it may be that they're held in a completely separate forum. So you have those risks. You have, just giving a few examples, there's been the claim in the UK courts against Unilever, which was brought as a result of the alleged failure of the parent company to protect its workers in Kenya in the aftermath of the 2007 election, post-election violence. There's a case, Opcabi versus Shell, again brought in the UK, arising out of oil pollution in Nigeria. And probably the most significant claim currently pending before the English courts is a claim against the mining company BHP Billiton in relation to the collapse of a dam in Brazil. And that's for a damages claim of 3.6 billion pounds. So these are not insignificant sums. What other risks do we face? Reputational harm. Now this, I think, actually exceeds your legal risk, because you can always find a way to meet your penalties, your fines, damages. But where you have reputational risk or harm, that is much more long-term. And as Howard flagged, in the social media age that we now live in, the court of public opinion carries incredible weight. And very often what you face is a significant censure from the public, which results potentially in further investigations and possible actions, but also can be significantly detrimental, not just to the business, but to individuals within the business, as we've seen with the CrossFit case this week. And then finally, there are business consequences which flow from the reputational harm or risk, where you have states no longer willing to permit you to tender. Many jurisdictions around the world have now set up specific tender programs which would exclude you from even tendering if you are suspected or have been found guilty of human rights violations. The equitable principles in terms of securing finance, and also where you are contracting as so many of you will find with other entities, both within your own jurisdiction, but also globally, is where there are questions around questionable human rights practices, then as a result of the obligations that are placed on other companies and other counterparties, there will be a reluctance to engage if you have been found to have violated any of these principles. So there is significant risk, and this risk needs to be mitigated and managed. So turning then to the next slide, please. The key role that we as legal counsel play for our organizations is trusted advisors to management. And so it'll often fall on in-house counsel to demystify the human rights obligations and potential risk. All too often we have seen that boards and senior management are unaware of the threat that human rights abuses can impact on the organization's reputation and long-term performance. And so what you need is a robust human rights policy, but that policy only works if you've had buy-in from the top down. So education becomes a very, very important facet of the role that in-house counsel play in this respect. Preparing or drafting a human rights policy is not straightforward. It needs to be focused on the particular organization's business and operations. And whilst there are certain broad overarching principles, there is no one-size-fits-all approach. The UNGPs are a great starting point, but there are questions here, and some of these questions we will consider in the breakout sessions later on. But how does one approach this? Do you have a standalone policy? Is it a policy that is integrated into your employee handbooks, into your supplier terms and conditions? How is this communicated, not just within the organization, but to your contracting counterparties? These are all questions that you need to ask yourself as in-house counsel. Howard touched on due diligence, and this again is both internal and external. The biggest issue, and this speaking from personal experience, where we have represented clients facing some of these issues, has been you have a policy that is fantastic on paper, but there is a big question around implementation and awareness within the organization. So the due diligence needs to be done. You need to think about past practices, what needs to be done to remedy those if there are concerns, but also a continued focus on training and development so that everybody is up to speed on what needs to be covered, what their obligations are vis-a-vis their own fellow employees, but also what they need to be watching out for when they contract with other parties. And as legal counsel, we find ourselves in a unique position where we're often involved in those negotiations with counterparties. We're often involved in employee disputes where you often become the first person in the chain to become aware of significant issues. So having the right protocols in place, having the ability to due diligence, not just internally, but also your counterparties and asking the right questions becomes very, very important. And then finally, we turn to remedying harm. Now, this is a complicated topic in itself because so many different outcomes can flow from a specific violation. And as we've talked about just a few minutes ago, the three main: business risk, litigation or legal risk, and also reputational harm. So it's finding a way to navigate these choppy waters and implement a protocol or a process that deals with these issues as they arise, but also does so in a way that is transparent, effective, and minimizes exposure to your respective organizations. So in conclusion, I think there's lots to think about, and we will touch on many of these points in the course of today's webinar, but there is a lot that falls on the shoulders of legal in-house counsel, and it's something that hopefully we can bottom out at least a little bit today. Thank you.
Yasmin?
Yeah, I'm trying to unmute. and start the video if at all
we
possible.
can hear you.
Okay, I've got it. All right, thank you. So thank you very much indeed, Howard, and thank you, Chiraag, for a most informative session and also almost in record time, so well done. Now, our next speaker is Catherine Musakali. Catherine is a corporate governance specialist and also a partner at Dorian Associates. Catherine will be providing corporate governance perspective and will be looking at the role of the in-house counsel navigating those legal challenges. So, Catherine, can I ask you to start, please?
Thank you very much, Yasmin. Good afternoon, everyone. I will pick up from where Chiraag and Howard stopped and just focusing on the three principles that they talked about: respect, protect, and remedy, and looking at it from a corporate governance perspective. Now, in corporate governance, when we talk about responsible business practices, ideally what we are talking about is sustainability in the broadest sense of the word. And very often this means that we are talking about conducting business operations in a manner that meets the existing needs of the business and the various stakeholders, but also at the same time ensuring that we are not compromising in any way the ability of future generations to sort of meet their needs. It means ensuring that businesses and organizations have what we have come to call the sustainability policy. And that sustainability policy often covers what has come to be known as environmental social governance. Previously in corporate governance, we talked about corporate social responsibility that moved on to corporate social investment, but now we are focusing more on environmental social governance. And sometimes accountants confuse this with the triple bottom line approach, which is slightly different because it focuses more on the profits as opposed to the governance pillar. So when we talk about the sustainability policy, the broad policy should ideally anchor policy pronouncements by the board in areas such as corruption, bribery, money laundering, privacy, data protection, and of course, fair labor practices, broadly talking about human rights. Now, very often, the head of legal, at least here in Kenya, also doubles up as the company secretary and therefore having a very special bond with the board. So in this role, I often find that the in-house counsel, as the person who understands the potential legal liabilities, should ensure that the board has adopted the broad sustainability policy, covering all those areas that I mentioned earlier. And in my view, this is the only way that the in-house counsel can ensure that the organization is avoiding unnecessary litigation. Now, when you look at the various codes of corporate governance, you will find that various regulators have indeed specified that boards must ensure that they have adopted sustainability policies. So allow me to talk about what we mean when we talk about ESG. So what exactly are we talking about? Next slide, please. So from a corporate governance perspective, when you talk about ESG, we are talking about economic social governance. So economic social governance, as you can see on the slide, has various components to it. And you have under the environment pillar, you have sustainability, environmental standards, you have quality of environmental reporting, goes to the whole question of if you have polluted the environment, how do you ensure that you have remedied the same? How do you protect the rights of the various stakeholders, including employees, including the communities who interface with the company or the institution? When you come to governance, how are you ensuring that you have transparency within the business? How do you ensure that the board is operating in a manner that speaks to responsible business? So very often, the E refers to the environmental pillar, which measures the company's impact on both living and non-living natural systems. So if you are a company in the oil industry, I come from the oil industry, and you are polluting the environment, are you really protecting the environment? So it reflects how well a company uses its practices to avoid environmental risks, to ensure that it is using environmental opportunities to deliver value to the various stakeholders. Now, when we move on to the S, next slide, please. Sorry, thank you. If we move on to the S, the social pillar measures the company's ability to generate trust and loyalty with the various stakeholders. Now, these various stakeholders will include employees, they will include customers, they will include shareholders and other stakeholders, including the regulators and government. And it is a reflection of its reputation and the health of the license to operate. And so it is more or less the company saying that we have a license to operate because we have ensured that we are respecting the key principles with regard to the social pillar. Now, moving on to the G on the next slide. The G is the governance pillar. And when we talk about corporate governance here, we are talking about the processes and the systems that the board and the company have adopted to ensure that the board is delivering value to the stakeholders, the broader range of stakeholders, ensuring that you're not just looking at this from a short-term perspective, but looking at it from a long-term perspective. So those are the three pillars, and these three pillars, as you will notice, speak to the three principles that Chiraag and Howard spoke about, responsibility, protection, and remedy. On to the next slide, please. So talking about, legal and reputational safety. So as in-house counsel, it really is the role of in-house counsel to make sure that the board has adopted, and not just adopted, but embedded policies covering the broad areas that we have talked about, covering anti-bribery and corruption. Of course, here in Kenya, with the Act of 2016, I think, every company is required to have a policy that requires it to ensure that it is eliminating bribery and corruption in its practices. So the board must ensure that it has such a policy. And all the other policies that are listed there on the slide. So the in-house counsel, because we do understand the impact of not complying, we have to ensure that we make sure the board has adopted these policies. And of course, I'm starkly reminded about Section 23 of the Penal Code in Kenya, which in broad terms states that where an offense is committed by a company or any other body corporate, every person who is charged with the responsibility of acting in control of that company or the affairs of that company would also be guilty alongside the company. Now, I am sure that as in-house counsel, you will agree with me that it will be very hard for in-house counsel to try and convince the court that indeed they had nothing to do with this commission of offenses, assuming it was discharging effluent into the river. So this is an area we must focus on as in-house counsel. And of course, there are personal consequences, not just for in-house counsel, but for the board as a whole. There are also consequences on the company, and we must bring this to the attention of the company. If I just think about some old cases which are still relevant, when you think about the Tesla case in the UK, where an attorney was actually found guilty for acting as a middleman. There are cases that show that in-house counsel could actually be held accountable. And of course, the consequences on the companies can also be grave. Think about the Siemens case, which there were criminal consequences as well as financial consequences, which were very, very hefty. So I want to stop there so that we can discuss later during the group discussion. Thank you.
So essentially, I think within each group, somebody would have been identified to give a little bit of feedback. I suspect it might be a little bit difficult for those groups who were only getting warmed up, as Howard said, and that included my group as well. But I'm sure everybody will do their best. So could I start with the legal frameworks group, moderated by Howard? So Howard, do you want to introduce the person who's going to feedback on behalf of your group? I think you need to take yourself off. Yeah.
The person who's feeding back is me. You already heard way too much from me, but I think everybody was way too respectful towards me because I had the honour of being a speaker. They will learn better. We were looking at the topic of legal frameworks, which binding and non-binding frameworks at the national, regional, international levels address responsible business practices. What are their strengths and weaknesses? And you know, there are spooky resemblances to our experience in the United Kingdom, because, and in fact, I would say that Kenya is stronger than the United Kingdom in explicit constitutional rights given to individuals and to the importance of human rights. And there is a infrastructure for those to be abuses and breaches to be brought before the High Court. But the challenges that individuals who may be the victims of human rights abuses face are the same that we encounter in the UK. Indeed, it is access to the court is difficult in terms of cost, difficult and daunting in terms of very often the people who are the victims of human rights abuses are in the worst position one can imagine to start trying to assert their rights. And then once one's overcome the difficulty of getting to court and obtaining a judgment, there are the problems of enforcement. And this seems to be something of a particular issue that Kenya is wrestling with, because made more acute by the current pandemic. And the illustration was given of protections against evictions.
Voice of the day enabled.
Oh, I'm sorry.
Do you want to open it?
Sorry, that was an Amazon Alexa device which suddenly decided it was going to. Jeff Bezos is listening. The enforcing rights is difficult, particularly that sometimes the executive, so the government, is reluctant, either the politicians or the civil service, to meet its obligations to allow the enforcement of judgments. Now, what Kenya does have is a number of agencies who are charged with effectively enforcing human rights protections and addressing issues, for example, in the provision of healthcare. And they have a quasi-judicial role, but they still struggle with dealing with non-professionals and individual victims. So I think the conclusion, and as I did say, I'm sure we could have talked for a lot longer as we became more and more comfortable with one another and expressing views candidly. I think that many of the problems that Kenya faces are the same problems that every country, and particularly my own, the United Kingdom, face in terms of addressing human rights abuses.
Thanks very much, Howard. That's very interesting. Okay, we'll next go on to the peer learning group. So Harrington, could you introduce whoever is going to feedback for your group, or yourself if it's you?
Thank you, Roger. We missed out on the warning and we are not able to select an independent reporter, so I'll do the summary about what our group discussed. Thank you. We had an exciting session and discussing peer-to-peer learning and on how in-house counsel in Kenya could benefit from interactive and peer-to-peer engagement with counterparts in East African community and in the UK. And the group felt that indeed BHR as an emerging area is quite important, and there's need for more capacity to be given to the in-house counsel in Kenya. And some areas that were identified for possible exchanges are one, to build capacity for in-house counsel to better serve the organization, especially in light of emerging challenges like the COVID pandemic. The corporations in Kenya are increasingly finding difficulties on especially how to deal with personnel issues. Do they lay them off, declare them redundant, send them on paid or unpaid leave? Which balance sheet will support that? And we expect that obviously when the situation settles, there are going to be costly litigations, especially by employees who have been laid off or who have been sent on leave. So in-house counsel would like to know, how do they ensure that confidently they are able to advise their organizations to avoid these costly steps and without also risking shareholders' interest in the company. The second area identified for exchanges and capacity building is the independence of the in-house counsel. An in-house counsel in Kenya very much might think that he's an advocate who holds professional independence and opinion, but then in reality, the in-house are working under directions of other lawyers and non-lawyers. How do they ensure that they are able to maintain their independence and they are able to give, advice to the organization without necessarily being coerced into adopting positions which are not compatible with their own ethics and even with the law? Thirdly, the strategic role of being a custodian of so much information within the organization. They know what happens in each and every transaction, and they are in a unique position of being able to whistleblow on potentially corrupt or illegal practices. But then how do they ensure they do this without, one, risking their own employment, and two, without risking their own professional ethics? It's assumed that as an in-house, when the corporate cloud puts this in your hand, you hold the information in privilege. But do you hold an illegal information in privilege? How do you ensure that we whistleblow without risking this? And fourth one, it was observed that when the UN Working Group visited the country in 2018, only a few in-house counsel were able to interact with them, obviously because probably many people still didn't appreciate what BHR principles are. Now, the in-house counsel in Kenya is concerned that they don't have more of a working relationship with this working group. They would like to know, how do their peers, especially in the UK, manage to interact with this UN, the UN Working Group and other international organizations that are directly working in the BHR area? So how have you done it in the UK? That is an area that we need a capacity in. And the fifth one would be on the existing laws and regulations in other countries. The in-house counsel, Kenya, as you appreciate, still doesn't have laws that touch directly on BHR. So would like capacity on what other countries already have the laws and regulations, how they did them, and if they can share with us those knowledge. And another interesting one is the fact that even though there is no law, there might be need to already build BHR functions within the legal department. And I believe in the UK, you have organizations like the Hilton Group that have already built this. So the in-house counsel here would like to know, how did they do it? How does the BHR function work within the traditional legal department? What challenges did they face in setting it up? And what lessons can a Kenyan company trying to set this up learn? And finally, in terms of now, after building the functions or before, you'd want to mainstream the BHR principles themselves into transactions, into functions. What experience is there outside there in the UK? What challenges have they gone through? And what kind of checklist do they have that they build into transactions, especially say procurement, hiring of staff, and community engagements? I think that is all we had from Group 2. Thank you, Roger.
Wow, there's an awful lot of questions, and actually really, really good ones, if I may say so, really interesting. Yeah, I think you've just solved my question as to what I'm going to say in my few minutes at the end anyway. I'll try and answer a few of those questions. Okay, could we go on to the third group, which was my group, and we did select somebody to feedback other than me, which was Jacqueline, who I can't see on my screen. Yes, Jacqueline Manani. So Jacqueline, would you, I know we didn't get a chance to work out what you were going to say in summary, but I know you'll do a good job, so I'll hand over to you. Oh, you're on mute at the moment. Sorry, Jacqueline, I think you're on mute.
Sorry about that. Can you hear me now?
Yes, we can hear you loud and clear.
All right, thank you. Our group didn't have much time. We were just warming up, and shortly we were cut off and back to the plenary, but we did have a bit of discussions, and we basically managed to discuss just two companies, or rather two organizations, the Public Service Commission of Kenya and the National Hospital Insurance Fund, both of which are public institutions in Kenya, in terms of whether, you know, what is our experience with the SDGs and the role of in-house counsel on sustainable development goals. And one of the things we noted is that the achievement of sustainable development goals requires both the participation of government and business. So basically it's SDG number 17, that without synergy or without participation of all players within the public sector and the private sector, you will not be able to achieve the goals. So it requires both participation of both government and business. And in this regard, both government and business are expected to incorporate the SDGs within their businesses, so that in terms of delivering on the same, we were given examples of companies that have incorporated the SDGs in their businesses, to the extent that they do annual reports on the extent to which they are delivering on the SDGs. So they have incorporated those that are relevant, and they're able to do the annual reports on the extent to which they're delivering on SDGs. For Kenya, we noted that the Public Service Commission has developed performance management regulations that are still work in progress. And those performance management regulations will then expect each public institution to incorporate the relevant sustainable development goals for which they have to deliver annually, and for which they will be assessed, or their performance will be measured against those particular SDGs that they're meant to deliver on. We noted the Big Four agenda, manufacturing, universal health, food security, and affordable healthcare, and noted the relevant sustainable development goals that fit within each of those. We also noted that it's not only the business incorporating the SDGs, but also expecting other organizations that work with the business or with government to incorporate those sustainable development goals. So for example, if you're a supplier to an organization, whether in public sector or private sector, then one of the policies that an organization can have is that for you to be able to supply goods to us or services to us, there are certain minimums or SDGs or bare minimums that we expect you to comply with for you to be able to be our partner. So that, we noted, should be incorporated either in policies or in regulations for government institutions, so that everybody is participating. It's that partnership. You're supplying goods to me. Are you adhering to the sustainable development goals? Are you delivering on them? If you are supplying services, the same applies. And also within the business, you strive to ensure that you're delivering on the various sustainable development goals that are relevant to you. We noted that the SDGs are used as a measure of performance. We use it as a mirror. One of us said we're using it as a mirror to check ourselves. What is the bare minimum that is across the world? So are we also adhering to the bare minimums and even making it better in order to achieve delivery of the sustainable development goals? I think that's what I noted. My group members, if anybody has something that I left out, we had a very short time, we're cut short.
As I had expected, Jacqueline, I thought that was a fantastic summary. So thank you very much. I think the only thing that I would add, which is really, if you like, from my perspective, from the UK and from seeing what other governments are doing, other countries are doing, it's actually, I draw out the same point that actually Howard mentioned, which is in many ways, Kenya, and particularly the public sector, has acknowledged and incorporated the SDGs and other things as well, like human rights enforcement, more expressly into law and into regulation.
Yes.
Than actually many other countries have, and certainly speaking, just as Howard said, for the UK, although the SDGs, are known, etc., they're not as central in terms of the way, at least, the government articulates its policies and so forth. We haven't got the equivalent of the Big Four, and that goes in several different ways, of course. But we don't have that sort of policy that you explained. So that's it. That's really that for me. I think that's an interesting point that both came up on in both Howard's group and in this one as well. So thanks very much, Jacqueline. If I can now move on to Catherine with Group 4, and you were looking at the impact of COVID-19. So Catherine, could you either summarise or introduce the person in your group who is to do so?
Thank you, Roger. My group decided that we are going to have 2 people reporting back. So we have Janet Onyono, and Janet will be supported by Joe Tan. So Janet, over to you, and then Joe will support you for that.
Okay, very good. Janet.
Maybe Joe can go.
Okay, so our group was quite an interesting one because we span from 3 continents, actually. We had us here in London, Vish in India, and a lot of Kenyan expertise as well in our group. So because of that wide variance, it was really interesting to hear our different experiences, and particularly in the employment sector. Of course, I spoke about our luxurious conditions here of having the furlough system, of course, which is unheard of in Kenya. And I remarked that many of my friends and colleagues in the Global South had to basically put the screws in really quite quickly. As soon as the first reported cases came in, and Vish will be testament, and he can talk about his experience as well in India. They would basically seal the whole building, and people weren't allowed in or out of the building. And this has contained, in terms of the figures that are coming out, it seems that it's working, but I guess the question is at what cost to human rights, which is what we're all concerned about here. I think the group generally was of a consensus that it was a little too early to tell yet. No one had seen untoward or very extreme stories of other than there were lots of cases of people being laid off unfairly or unlawfully in many instances. And in terms of labor rights, those were clearly violated. But because of the furlough scheme, of course, in London, we don't have, that's got to play itself out, I think. We also spoke about the tensions between the rights of people to be treated and the rights of medical staff to be personally protected. And we talked about the duty of care and the heightened duty of care amongst health workers and people in aged care homes, for example. And I shared our story here in the UK, and also the experience of Sweden, which has had their aged care home sector ravaged by a lot of fatalities. Yeah, we spoke about the state of emergency and the greater leverage that gives to governments at this time, but the fact that that's not an absolute right for governments to, there is a boundary to what they can do, and it has to be proportionate to the context and circumstances at all times. Did anyone else from the group want to add? Maybe Vish, you might have a
could I ask whether you or somebody else perhaps hone in a little bit about on whether you talked about, you know, the experiences or issues that in-house counsel in particular have been having. I think you mentioned it was largely around the employment issues and so forth. So anything else that was particularly, if you like, picked up in terms of, you know, the sort of business, the businesses issues that were on people's desks?
We didn't touch too much on that. I think the consensus was that so far there weren't any problems that had been very obvious at this point in time.
Okay.
But yeah.
Okay. Very good. Well, should we? Sorry. So Janet, I don't know whether Janet has come back or no. Okay.
I think we can. Yeah. I think Joe has covered it all, so we can.
Okay. Yeah. Very good. Well, thanks very much, Catherine. So we'll move on to access to remedy, which is Chiraag. So Chiraag, can I hand over to you?
Great. Thanks very much, Roger. And we also weren't able to select somebody. I did ask for volunteers, but we deemed it maybe an affront of human rights to force somebody to put themselves forward. So it's going to be me.
Go on.
So we approached it from two angles and two specific scenarios. So one where there was a internal issue, and secondly where it was a human rights issue identified with a contractual counterparty. And so starting with the internal issue, the thoughts predominantly were that there were three key aspects to cover, and that was knowledge, communication, and action. And the knowledge was trying to understand as much as possible, as quickly as possible, about what had happened, and understanding not just the background, but also potential implications, who the relevant stakeholders would be, who may have been impacted or affected, and whether there was a wider repercussion outside the organization itself. Messaging then was a discussion around what you would say internally, both within the corporation or the entity itself, but also messaging to the senior management and what they in turn would want to have as their outward message, particularly initially when something springs to mind, and whether in fact there was already a social media or press speculation on the issues at question. And then finally, we talked about action and what needs to be done. And the conversation focused on mapping out the risks where you set them out into buckets of high risk, medium and low, and then therefore be able to prioritize the action plan going forward. In relation to the third-party vendor or contractor issue, that was actually a more interesting conversation. And we talked about a sweatshop scenario where you find out your contracting partner has been breaching human rights in its particular jurisdiction. And it was quite interesting to hear some of the thoughts which centered around the socioeconomic effects, where sometimes individuals may be working in harsh circumstances, but that is the only way to earn a livelihood. And so how does one balance that against what the human rights principles and the UNGPs may say about a safe and acceptable working environment? We also talked about mitigating facts and looking at what policies internally may have been implemented at the time of contracting, and why it was so important to get this right at the outset, because you then have a proper procedure to follow as and when issues like these are discovered. We were cut short on what was going to look to be a very interesting question around what was happening locally in Kenya around COVID and insurance claims. But I think it's something I don't know whether Nanette wants to add something to what we just discussed, or whether we park this for a further session.
Sounds like we are parking this for a later session. That's really interesting there. Okay. So finally then we can move on to moving forward, and I'll hand over to you, Yasmin, on that one.
Thank you, Roger. So we have Rose Osimo, who's going to talk about what we discussed at our meeting, at our breakout. So Rose.
Rose,
Rose
is Rose on?
Yes, she's just about joining, I think.
Great.
Yeah, I'm here.
Hi there, Rose.
Hi, how are you?
Fine, thank you.
Okay.
So go ahead.
So in our breakout meeting, we had a good discussion. Yes, so in our breakout meeting, I think we are the only ones who almost finished the discussion. So we just basically went through the support needed in our everyday role as in-house counsel. That basically means that the challenges that the in-house counsel were highlighted, the desired support was brought out, and we saw the practicality of excelling in the role if this support was provided. So I think we were about 6 or 7 or thereabouts, and we were in sync. The in-house counsel is desired to be a crucial part in decision-making process. The in-house counsel needs to be trained, needs to be enlightened to work hand in hand with the dynamics of the law in order to be an exemplary contributor in the day-to-day changes in the business, in the organization. We also saw the need to have the in-house counsel recognized as part of the decision-making team, which means the board of directors. If the in-house counsel can be given a seat on this table, it would make a big impact based on the fact that the role of the in-house counsel has really changed, has really grown in terms of the portfolio that they previously handled and what they're handling now. They're now business partners and just not any other employee, for lack of a better word. So in our group, we saw the need for trainings, we saw the need of pairing up, having platforms where we can exchange ideas, we can build each other, build rapport, and maybe lobby for change. we also saw the need to have access to the change in legislation, to have access to policies, to take part in developing policies that would enhance the growth of the business, with the legal counsel taking a big role in being part of that. I'm not sure if there is anything I've left out, Yasmin.
No, you covered that brilliantly. Thank you so much, Rose.
Yes, thank you. Excellent. Okay. Well, thank you, everybody. You know, this was, I think, for all of us, a little bit of an experiment as to whether this would work. And yes, we had a relatively short amount of time in there, but you know, a lot of interesting ideas have come out of it. So maybe if I just try to sort of summarize what I've heard and you know, maybe answer a couple of questions that were posed there as well. Actually, I'd probably start almost at the end here in, I think, something that Rose you mentioned there, which I think is important and implicit in fact what we heard from a lot of the other groups as well about the role of in-house counsel, in-house lawyers, which is that, you know, that's a role which has grown in your experience in Kenya, and what I can say is I think that's reflective of what has happened, you know, around the world as well. So you know, that really sort of, if you like, struck a chord with me, that, you know, many of the in-house lawyers and general counsel that I work with have seen that happen over, I can tell you, the 30 years I've been in practice, from a position where, if you like, the lawyers were just the people who, you know, documented things and just, you know, just were, if you like, more administrative, to being regarded as essential people with a voice in the decision making of the organisation. And sometimes, certainly in the UK or in global organisations, I've heard the expression used that the general counsel is the conscience of the organisation, which I think always thought was quite a nice phrase. And also the guardian of the reputation of the organisation. And I think, you know, that's something which is developed elsewhere, and maybe my colleagues have had, I saw Howard nodding there, sort of seeing the same sorts of thing. And I think it's, if you like, feeling that you should, as you know, in-house counsel, should feel that's a model which, you know, has been developed and has been accepted elsewhere. And that should be your aim, in my view, is to be that. And obviously, actually picking up on something that was said from one of the other sessions, I think it was you, Harrington, was talking about some of the difficulties that might be faced by in-house counsel in fulfilling that sort of role. And essentially, you know, I think what I've seen is that essentially, for that to work, requires the board and the CEO of the organisation to have expressly bought into that and into that role for general counsel or for in-house counsel. So actually, there's a topic which we haven't talked about today, and it's one of these other topics that's quite connected to what we've been talking about, has been corporate culture. And that's now become, if you do a web search for corporate culture, you'll now find a lot of information on that, where there's now a real focus, actually from regulators as well as from others, that actually what makes an organisation function and not do, if you like, not do bad things, to put it very simply, is that they've developed a strong and positive corporate culture. In other words, that people do the right thing because it's the right thing and they feel that's what the organisation expects of them, and they're not just doing it because they think somebody's watching them. In other words, some people say it's about what people do when they're not being watched, and do they do the right thing. And the phrase that's specifically used there is called tone from the top, and I don't know whether it's been used in Kenya at all, but it's this idea that culture, that strong culture and positive culture, which includes listening to in-house counsel saying, you know, we need to do the right thing here and we need to stop doing something that's wrong. That needs to be something that everybody recognises, that the senior management expect and support. You know, because otherwise, if the junior person who you say, actually, you need to stop doing that or not doing that contract because of X, if they feel that all they need to do is pick up the phone to the boss and say, hey, the lawyer's stopping me doing this, but it's going to earn us money. If you can't trust your boss to say, no, you know, if Rose says we can't do it, we can't do it, then you're never going to be empowered. And that's what you need to work on, really, is that you have that corporate culture and that, you know, it's supported at the top in terms of the policies, but also the way people behave. So I think that's one sort of thing that I very much picked up from what you talked about. In the short time we've got, another 30 seconds. It's actually, again, Harrington talked about, you know, that his group wanted to know about, you know, how do lawyers in other jurisdictions like the UK go about having that dialogue with things like the UN Working Group and so on and so forth. Well, one of the main ways that happens is actually through the UN Global Compact. So actually, the UN Global Compact, you know, does have branches around, you know, the globe, and I know they have one in Nairobi because I've met them. And they support businesses generally, including in relation to the implementation of the UN guiding principles and all of the UN things, including the SDGs. So really, it should be it is actually the constitutional role of the UN Global Compact to support businesses, and that must include in-house counsel as well. And they were certainly interested in talking to us about the role of in-house counsel. So I'd probably say, from my experience in Kenya, it's the UN Global Compact, and it is the same in the UK and elsewhere. UN Global Compact is a route through which businesses and in-house counsel, together with external lawyers, can work on this. The other thing, which is really, we ought to facilitate a dialogue with the UN Working Group. We know them. I know some of the members, I'm sure some other people do as well, and we ought to be making sure that happens so we can do something practical for you as well. So those are a couple of thoughts I had around that engagement, because I think that's very important as well. We've just hit 2 o'clock, so I will stop there, because I know I need to hand back to Yasmin and others just to finish us off as well. But can I just say thank you very much to everybody for participating so positively and enthusiastically in this part of the session. Thank you. Back to you, Yasmin.
Thank you very much indeed, Roger. That's great. Thank you for your remarks, and also thank you everyone for sharing your discussion points. I have had Jackie Ngutia, who just wanted to inform people with regard to Kenya, and I suspect you all know this anyway, is that one of the questions was about whether or not there is policy in law on the UNGPs within Kenya. And the answer is, of course, yes. They've been working quite hard on the National Action Plan for a number of years. Indeed, A4ID was involved when Jackie was working with us on this. And at the stage that I believe that it's at now is a very advanced stage. The action plan, National Action Plan, was presented before Cabinet for deliberation, and they have submitted indeed their feedback to the AG now, who is reviewing the feedback and will be responding hopefully quite shortly. So just to let people know that. So we are now at the end of the webinar, which I hope you all found informative. We'd very much value your feedback on the session, and we do hope that you will join us again in future events. It's nice to see some people nodding, that's good. Now, I'd like to say a very big thank you to our speakers for their insightful contributions, to Hanningtone, to Ndinda, Howard, Chiraag, Catherine, and to Roger. Thank you for sharing your experiences, your knowledge, and your thoughts with us on what is, after all, a very important subject area.